And then there were all kinds of ways that everybody got around that. And so the McCain-Feingold Act, which is the one at issue in Citizens United, went beyond that and said that, okay, if they are electioneering communications, and there is a statutory definition of what that means, then you can't use your corporate funds or your union funds to fund them during 30 days before a primary, 60 days before a general election. And that provision was upheld by the Supreme Court on its face in the McConnell case back just a couple of years ago. And it's not only is McConnell being challenged, but another one of the major U.S. Supreme Court decisions involving the funding of campaigns by corporations. Basically, I think what's at issue here, and maybe the simplified terms, is are corporations entitled to the same First Amendment free speech and associational rights that individuals are? And since 1907, corporations have been restricted in using their own funds in federal elections. And it sounds as if the court is maybe on the verge of overturning that.
And how would that make...
Let me just follow. That's why I say there's a technical issue and a speculative issue. The technical issue, I think Don explained extremely well. The speculative issue is after this was argued last term and should have been decided last term, the court issued an order for re-argument directing the parties to brief whether or not 2 previous cases should be overruled. So that's what leads to the speculative question: why did they do this? Was there sentiment within the conference when the court decides a case, it has a conference, sits around a conference table and talks about the cases? Was there sentiment within the conference on that case that the court had taken the wrong path with respect to the relationship between the First Amendment and these campaign expenditures, the path represented by these cases that Don was referencing? And so now the speculation is that there might be sentiment to overrule those cases, which would be a significant change.
And how would that affect the way...
A couple of members of the court who, it's pretty clear from their prior decisions, do not think there ought to be any restrictions on campaign funding. And there are a couple who have already expressed themselves, you know, Scalia, for example, Thomas, probably Kennedy on this one, who also have said they think corporations should be entitled to exactly the same status as individuals with respect to their participation in the political process.
So if the court does what Ron speculated, and many are speculating, I guess, might happen, and overrule this rule that's been long-standing, what kind of effect would that have on elections?
Katie, bar the door. It will have a very dramatic effect, not only with respect to the amount of corporate money that can go into campaigns, and there's a huge amount of corporate money out there that can just begin to flood the political campaigns around the country. And even though I suppose you could say this is not the best time for corporations to be contributing to anything, since everybody's in bad financial shape, there's no question that it's going to change the way in which campaigns are funded and enormously increase the role of corporations, and not just profit corporations, but also not-for-profit corporations. And whether we're going to be able to offset that is, you know, it's going to be a real struggle, I'm afraid.
Yeah,
Sure.
I think like Yogi Berra said, predictions, especially about the future, are difficult.
Agreed.
One of the difficulties in this area is that the political and the economic dynamic is so complicated that any regulation of it is extraordinarily difficult, so that you pass a campaign financing law thinking you're going to accomplish a certain purpose, but it interacts with this incredibly complex economy and incredibly complex political dynamic. The consequence of that is that people adjust to the new rule and figure out ways around it. So Dawn is concerned about opening the floodgates of corporate expenditures, and she's actually really concerned that she thinks that's going to be predominantly on one side of the political equation, not the other side. My guess is that there would be increased expenditures, but not anywhere near the floodgates level, because in fact people have constantly, every single time Congress passes a statute, figured out ways around it. That is to work within the terms, but to actually accomplish the purpose that you're trying to accomplish. So, for example, when limits to PACs, political action committees, were established, a genius accountant somewhere figured out, well, there's no limit on how many PACs there can be. So you can have
so you just get around it.
1,000 PACs.
Yeah,
there's no question. Let me just add one thing to that. Apart from the fact that we slightly disagree on that point, Ron, one of the things that bothers some of us who have been heavily involved in trying to put some reasonable control on the sources of campaign funding and how they get distributed, is that this may be just the first step. It may be that the court is not just getting ready to say that there's no limit on, there can be no artificial limit on what corporations can contribute in the process. But there clearly are a few members of the court who don't think anybody ought to be limited at all. And that means that everything could conceivably, over a period of time, open up. As somebody who has been in the political process, I think that is very unhealthy. I really do.
Yeah. Now, another issue that will be before the court this fall, which is quite controversial, is the constitutionality of Chicago's handgun ordinance. And that's before the court in a case called McDonald versus Chicago. Ron, what's the issue in that case, and why do you think the court took that case?
Well, again, why they took the case is because four or more people voted to hear it. That's the only answer I can give to why they took the case. So here's what's happening. Two terms ago, in a case called Heller, the Supreme Court struck down a Washington, D.C. Gun restriction on the basis of the Second Amendment. The Second Amendment guarantees the right to keep and bear arms. There is substantial ambiguity as to what it meant. It has a prefatory phrase that says well-armed militia being essential to the security of a free state, the people have a right to keep and bear arms, something like that. And no one knew if the prefatory phrase constricted the scope of the protection. So in other words, the reason you had a right to keep and bear arms was in order that there be militias so that you can secure the independence of a free state. The significance of that is if those two are connected, then gun regulation that has nothing to do with militias should be okay. The court basically said that's a prefatory, not a descriptive phrase. And so so basically there's a right to keep and bear arms. But the Second Amendment, as actually all of the amendments, applies only against the federal government. And if you read them, you can see it'd be crazy to think otherwise. For example, the First Amendment actually says Congress shall pass no law. Well, it's pretty obvious what they're talking about.
There's only one
Congress. In the middle, I'm going to have to give a long story in a very short version. In the middle of the last century, the Supreme Court started interpreting the Due Process Clause of the 14th Amendment to what they would say absorb selective aspects of the Bill of Rights. Now, virtually all of the aspects of the Bill of Rights have now been absorbed, except the Second Amendment, maybe the Third and the Seventh Amendment, civil jury trials.
Yeah. Double jeopardy to some extent.
Double jeopardy has been.
And why is the Chicago case important?
Well, that's
in that
what
respect?
I'm getting to. So now the question is, is the Second Amendment going to be absorbed into the Due Process Clause like just about all the other amendments?
And being absorbed into the Due Process Clause means what?
It applies against the states.
Yeah.
So the states are now restricted in their ability to restrict the possession and ownership of handguns. So, for example, if they find it to be absorbed, to be part of due process, then this Chicago handgun law, like the Washington handgun law in Heller, is likely to be unconstitutional.
Very likely would be unconstitutional. Yeah. And it's interesting because you've got sort of two conflicting trends, I suppose, involved here. One is the Second Amendment itself and restrictions on handguns. And of course, a lot of people feel very strongly on either side of that. But there's something else that a number of the members of the Supreme Court tend to feel very strongly about, and that is a protection of what I guess you could call the federalism principle, which so underlies our structure of government in this country. In other words, that the states are laboratories of their own, and they should be able to experiment and do things that are not necessarily dictated by the federal government.
And what would that mean here?
Well, that would mean that they would not incorporate the Second Amendment.